I am honored that I was asked by the Chairman of the Honorable Law Commission to speak today on a subject which delightfully has come to occupy center stage. I'm happy that we are discussing this under the aegis of the Law Commission, which has been involved in the debate more than once about the need for reform in the appointment of judges. Under the aegis of the Niti Aayog, because that reflects a recognition that as justice is not a cloistered virtue, recognition of candidates for judges is not the monopoly of judges. We have to examine this question under the paradigm of the theme of this conference. The theme of this conference is about the three wings and their role in the development of India. The three wings: the executive, the legislature, and the judiciary. The Constitution looked at all three and made provisions for all three. But the Constitution, as the Supreme Court has repeatedly recognized, and fortunately we have never had any doubt, is an organic instrument. It has served us well. It is, if there has ever been any need for amending the Constitution, it is because we have not served the Constitution well. It has served us well because it has served as a roadmap, as the holy grail of how India has to develop to deal with its problems of poverty, backwardness, but within the architecture of a democracy. But what has changed over the decades, and that's been one of the greatest contributions of the technological advance of the 20th and 21st century, what has changed over the decade is public interest and public awareness in the working of all three branches of government. And it's the three wings, the working of which should be examined dispassionately, objectively, and with an eye of serving the spirit of the Constitution. The two wings, the executive and the legislature, have, as they must, a close relationship. The selection of the executive has shown gaps. The relationship has had problems. But can anybody doubt that the elected wing can and must play a vital role of a stakeholder in the selection of the non-elected executive? Can you ever countenance the idea of the executive becoming a self-replicating organization? And if that can't be, then we must have a hard look at the present system we have and decide whether we need a change. When we discuss the role of the present, the working of the present system and the architecture of the present system, we must remember three evolutions which have happened. The change in the role of the judiciary itself. From a tribunal deciding disputes between parties, today's Supreme Court has become one of the most powerful organs of governance, of accountability. If that is the role of the judiciary today, who are the stakeholders and what should be their role in the selection of those who discharge these duties? And that is the spirit in which we must examine this question. I start by prefacing my address with a degree of sadness which I have felt every time we have debated this issue. Every time we talk about this, it degenerates into a discussion of who made bigger mistakes in the process of appointment. It's the wrong end from which we address the problem. No institution is infallible. The appointment by the executive under the old system gave you the Gajendra Gadkars, the Vivian Boses, the Krishna Iyers, the Chinnaparadis, people who have fashioned the evolution of our constitution, the Bhagavatis. And yet it faltered at one point when the Supreme Court had to intervene in the first, second, third judges' cases. I'm not going to discuss those three cases because we all know them, and besides, it's not going to help. But there was a problem. The court had the constitutional provisions as the outer limit in which it could change the method of appointment. But today, when we discuss this issue, we are unconstrained, and we should be unconstrained, not limited by the existing structure of the Constitution. If the Supreme Court needed to make a radical change in 91, although limited by its language, let's consider radical changes unlimited, which should best serve the purpose. Therefore, to keep a long distance between the kind of acrimony we have seen and to look at it from a conceptual point of view, I thought, let's work with one format, or at least that's the format I have adopted for my keynote address. And that's the Cape Town Principles. When we started writing papers with the Cape Town Principles, it was based on a note which had 10 markers, apart from the omnibus marker of anything else. And those 10 markers are very important, and they point in a particular direction. Those 10 markers were, why did the jurisdiction, and this was a global examination of appointment of judges in democracies. Why did the jurisdiction establish what they call a JSC or a JSC, a Judicial Appointments Commission or Judicial Selection Commission? Why did the jurisdiction appoint that? All jurisdictions started with the government appointing judges. All jurisdictions have drifted towards a selection commission or an appointments commission. Why? What's the first marker? The second marker was the legal framework within which it operates. The third marker was, how is it comprised? Are the members appointed in an ex officio or a personal capacity? What are the constituencies from which members are drawn? How are they selected? What is the criteria for appointment of members not serving ex officio? The fifth marker, what is the period for which the members are appointed, their qualifications, etc. Sixth marker, what other mechanisms are in place to ensure individual independence of members? If judicial independence is vital, we must have a selection system in which the selectors are equally independent. Is there an oath of office or code of conduct? Are members remunerated? Do those members represent organizations exercising their own judgment, or do they come with a mandate? How is the institutional independence of such a commission assured? Two key elements. How do we ensure the independence of the members? How do we ensure institutional independence? After considering a two-day discussion, the eminent jurists comprising the Cape Town principles came up with a set of principles which they declared, and I propose to read some extracts, only to show how close the world is on recognizing the need for the appointment of good judges, and how common, how shared are these values of what a judiciary should be. The first principle is that an independent judiciary is indispensable in any country to uphold the rule of law and to ensure access to justice through the courts. The ability of the judiciary to discharge this responsibility depends upon independence, impartiality, integrity, and professional competence of its members. The principal objective of any system of judicial appointments must therefore be to identify and secure the appointment of persons who possess these qualities, and any additional attributes that may be stipulated for positions that require specific expertise or leadership. We have come a long distance from saying we need to find good lawyers to become good judges. Nobody in the civilized world now differs on the basic virtues. There is nothing esoteric about the basic structure of the Indian Constitution, which undoubtedly guarantees to each one of us a powerful, independent, and competent judiciary. And that's a value we share with most of the civilized world. The Cape Town principles go on to say the process of selection of an appointment should be conducted fairly and in a way that encourages the best candidates from any background, mark the words, to seek a judicial career. And that generally enhances public confidence in the judiciary. How far are we from this principle? The third, appointment to judicial office, and this reflects what the Honorable His Excellency the President reminded us of this morning. The appointment to judicial office must be open to all suitably qualified candidates without discrimination on prohibited grounds recognized in international human rights laws and applicable domestic law. Depending on the context of a particular society, measures may be required to redress past or present patterns of unfair disadvantage or exclusion, affecting actual or potential candidates differentially on the basis of race, gender, or other characteristics. It went on and made suggestions of how independent commissions should be appointed, something which we in the panel discussions can explore. There are 2 or 3 quick points which I need to make. The first is the role of the stakeholders. Are, quote unquote, lay people, strangers to be kept at bay in the judicial selection process. The most vital shareholder, the consumer of justice, should he be told stand outside the portals when it comes to selection of judges? Or does that impair the credibility of the process? The executive, the most critical stakeholder. And I want to deal with one heresy up front in my keynote address. Yes, the executive is interested in the result of cases, but they are cases very few and very far between. If you want to know how the executive is so critically interested in the result of cases, come and see the working of how government agencies work in courts. They couldn't care a tuppence about how government cases are decided. So we conflate two distinct issues. We say the government has the largest number of cases. Yes, but the government also has the largest number of cases mishandled because of lack of interest. Yes, there are cases which have political connotations, in which the government is interested in the result one way or the other. For that, should we say that the executive is not only not a stakeholder, but has to be kept at an arm's distance from the appointment process? There's a huge gap between allowing the executive the determinative, the critical role in appointment and allowing the executive a participatory role in the appointment of judges. What then about the NJAC judgment when we discuss the way forward? That judgment is deeply flawed, and hopefully, when tested again, may not hold. Most of the judgment is unnecessary, but it became necessary because of points run by the government which should never have been run. Our constitution has to be read literally. Fortunately, our court has never accepted that. That the basic structure comprises of the original text. Chief Justice Kerr, as he then was, uses this to hit the government with the argument saying yes, and therefore the Chief Justice of India is part of basic structure. It then goes on to say that any system in which the choice of judges can be negated by a veto of the other stakeholders is destructive of independence of judiciary. That is a completely unwarranted leap of faith. Judges of fact and law need not be necessarily good judges of human character. We need an institutional mechanism. If an institutional mechanism is better equipped to deliver selection of people who are impartial, who are independent. Impartiality and independence come from strength of character. I remember the Law Commission in its 80th report went through all the systems. It marked the Conseil d'État, the French court. And I remember, whenever I hear of that, I remember what Mr. Sirvai told the bench hearing the first judge's case. He said, and he was arguing about independence and about the tenure and about the appointment of judges, and he said something which, as a young lawyer, I heard and it has stuck in my head. One of the most powerful courts which has taken on the government time and again is the Conseil d'État of Paris in France. And those are judges selected by the government without security of tenure. And he told Justice Venkatramaya in reply to a question which I can never forget. He said, ultimately, impartiality and independence is your character. It doesn't come from the fact that you're selected by the Chief Justice. And it doesn't disappear if somebody else selects you. The independence of judiciary is unquestionably a part of the basic structure. But to suggest that this is destroyed unless you have only our system of working it means that nobody else except India in the world has an independent judiciary. An argument which has to be stated to be ridiculed if not rejected. What about other countries where we have powerful judiciaries? Look at the American system of appointment. I'm not saying we adopt that, but it works beautifully for them. Can you say the US Supreme Court is subservient to the other wings of government because of their role in their selection of judges? Or because the US judges are hopeless? or they lack the professional skills. What about the English judges? Look at the English judges and the way they perform. They have taken on the government on Brexit, the most politically hot potato. And look at that judgment is such learning if you read it. What about those judges? They were not selected by the Lord Chancellor or the Lord Chief Justice. What's the way forward? The way forward is we need to discuss this untrammeled and unhindered by anything which we have seen or heard in the past. The last word has not been spoken, and in the evolution of human institutions, I think it is the strength of society that the last word is never spoken. We can always be wiser. Some principles ought to be rendered immutable. Let us make sure that no court is ever made to hear an argument that the basic structure actually itself doesn't exist, or that the Constitution should be read literally and pedantically. Some principles should be rendered seriously moot. And those are that unless the Chief Justice of India has the last word in the selection of candidates, there will be no independence of judiciary and the basic structure is violated. What should be rendered moot is what have we got today? A self-replicating system. No institution in the world is of this kind in a democracy. What has to be rendered moot is the proposition that an executive has to be kept at bay in the appointment of judges. It's a long distance from saying that they have to be given a decisive role. What has to be rendered moot is the suggestion that lay persons, a word used derisively almost, can ever bring value to the table when it comes to appointments of judges. Justice is no longer a cloistered virtue, and the appointment of judges is no longer a secretive process. Look at where the collegium system has been pushed to by the power of public opinion. And I am, speaking for myself, deeply disturbed at seeing what is now going to happen. If in this system you try and introduce transparency, you are publishing the names of those you appoint. Are you going to publish their biodata? And worse, are you going to publish the names of those you don't appoint and why you've not appointed them? And are you going to then save yourself from suits of defamation? Some of us who've had some little familiarity with the appointment process knows there are howlers. Justice Kirpal used to publicly give the example of one person whose name was shot down twice for appointment because the secret report said he was by his friends called Boozer. And he was called Boozer because amongst his group of friends, he was the only one who was a teetotaler. Would you have published this? And what would have happened if this had been put in public domain? One more reason why we need to change the system. We need to change the Supreme Court from the onerous task of appointment of judges. We have seen where the institution has landed itself. We have heard of the kind of public exposition of internal differences which have shaken public confidence in what has to be a powerful institution, a bulwark against the executive. And a house divided is not a powerful house. So we have to save the Supreme Court from this onerous task. The way forward, and I see Mr. Khan sitting there, the way forward is appoint eminent people who have a commitment to the Constitution, who are familiar not just with principles of constitutional law, but with the social science of selection of human beings who will be tall enough to wear the badge of a judge of an Indian constitutional court. Ask them to study the global systems, ask them to study the Indian milieu, and ask them to tell you how we should now once again attempt to create an institution so that in your next conference, sir, the President can speak of the 4 pillars of the Indian Constitution: the executive, the legislature, the judges, and an institution that selects the judges. Thank you.